First of all, I deeply appreciate and congratulate the Ambedkar Students Association in organizing the post Rohith Vemula incident from the day even till today without any break, consistently taking up this cause. And the way, I'm really wonderful the way the Prashant has delivered. Whenever there is a matters, Prashant and all ASA students who comes to the office, बहुत साइलेंट से बैठते लेकिन इतनी बेहतरीन बहुत वोकल I was really very happy to see this have spoken. Friends, I'll just focus on why we need Rohith Vemula Act because of the time constraint and also there are other very important speakers to speak. Why we need, and we may also have a question within ourselves that when there is already an act like a CST Prevention of Atrocities Act, what makes the difference or what is the necessity to have a new act? This is an ordinary man can also get the doubt. First of all, we have to understand that the Indian society is basically of twofold of things which are very essential to understand. One is the caste bias and another one is the class bias. This caste bias you can see in all the institutions. Even judiciary is not an exception to this, my friends. You know, why we could see in the modern days this deaths had been taking place in the universities in the form of suicides. Why could not able to notice even before this? Basically, when you see post-emergency, the depressed classes from the marginalized have started coming into the higher education and the universities. Before pre-emergency, you know, there was no space at all. Dalits even, they could not have an access to the education. When the movement has started the post-emergency, and in the modern days, we could able to see the Dalits entering into the universities could not tolerate by the dominant caste. That is one of the strong reasons to see such an institutional discrimination. Just I have seen the report in that Rohith Vemula where the Union Law Minister himself has reported to the Parliament that more than 200 plus deaths had taken place in various universities. And out of 200 plus, nearly majority of the deaths were from the depressed class. Dalits have died. And thousands of students were dropped out from the universities because of various reasons of discrimination on the students. The history speaks that no ruler in the world, in the entire history, that out of the love of the people, they have given us the rights. Rights we could only achieve through the struggles. That is the reason I don't believe even today that these government would come up with an act. Only we can achieve the act, Rohith Vemula Act, by great struggles, by student movements, civil society, lawyers, academicians should come on the streets and we have to fight. Then only we could able to achieve the Rohith Vemula Act. You know, to get an act of 1989 SC/ST Prevention of Atrocities Act, how many of Dalits have sacrificed their lives? Hundreds of thousands have sacrificed their lives and met with atrocities. When an incident has taken place in Karamchedu in 1984, or then if you see Chundur in 1992, the situation was so pathetic was that even today in India, in our country, a victim of atrocity to register an FIR, you know, minimum is at least you have to organize a protest in the form of dharna or a huge meetings, or else you have to approach the courts by way of filing the writ petitions. This is a situation now prevailed. With a great difficulty, with the help of the civil society, all the activists, if you could able to approach the police, the FIR could be registered, but that would be at the interest of the station house officer. He'll say, remove names, so and so names should not be there in the complaint. Boy, he's an influential man, it's very difficult for us. This is how the spirit of the complaint would be entirely changed. You can see now the perpetrators of the institutional murder are now they're set free. They are not facing any criminal prosecution. But whereas the victims, those who have raised the voice against the injustice, are now facing the trial. And the post-Rohith Vemula death, there was a huge protest across, not only in the Hyderabad Central University, but we have witnessed across the country internationally. But when you see so far of the university, number of FIRs were registered against the students and also academicians, all flimsy grounds. Protest is a basic fundamental right, but at the instance of university authorities, politicians, it has been criminalized. Now, very interesting, our cases, when we have faced lodged a complaint, without the notice to the complainant, you have closed it. Though the law mandates that if you want to file a closure report, you have to give a notice to the complainant. There is no notice at all. But so far as the cases concerned on the students, you are hunting through the warrants, sending the notices through the WhatsApp. This is the nature, the state. Though there are different forms of atrocities, you see. Nowadays we see the honor killings. Right to choice has become a crime. Now the institutional discrimination which has led to many to commit suicide, and also some have left the universities. When the Act of 1989, SC/ST Act was drafted, now the draft which now we see in 2025, during that period, the persons who are drafted, they were not have any, the understanding or reachable to the urbanized discrimination. That is the reason in the original SC/ST Prevention Atrocities Act, you only see rural atrocities, where the atrocities are 10 to 12 atrocities were identified. Those atrocities are more concentrated at the village level. Feudals, semi-feudals, upper caste, dominants, a right to, you are denied to have an access to the public well. In fact, it is a right to have an access to the well. Then that is the reason all the atrocities which are identified, those in 1989. But when an amendment had taken place in 2015, you could see a large number of atrocities were identified. Social boycott in 1980s could not be identified. Now in 2015, the social boycott is an atrocity. Right to vote by a Dalit is an error. Now if you stop, it is an atrocity. The right of a choice to choose to vote to whom is also a right. Therefore, today the biggest challenge before all of us, we have to redefine the rights which are achieved through these struggles are now being slowly taken away, one after the other. And courts are totally hostile. 90% of the judges in this country, they do not know that the SC/ST Prevention of Atrocities Act is existing. And it's day in, day out, it's a big burden to us to say that what are the rights of victims. That is the reason 90% of the cases will end up at the stage of filing charge sheets. Under these circumstances, what I particularly say that to achieve this Rohith Vemula Act, we are all the academicians, those who love the rights, those who believe in equality, those who believe in human society, all have to come together. We all have to raise the voice, protest against this state pathetic situation, very passive. In fact, this Congress government has promised a long back that the moment we come into the power, we would come up with the act. But you know, till today, there is no such any movement from the state government. Of course, we know about what would be the fate in the central government. The way, if you see, you do not find in this country one sumoto state has got registered an FIR when an atrocity had taken place. You do not find anywhere in this country. Unless a victim goes to the police station, stands in the police station for hours together, and he was not made to sit, but the accused will just straight away go and sit before the sub-inspector or police officer. And nowadays, it is another strategy which has come up in all the atrocities cases is that counter case. The moment a case is, we go to the police station to lodge the complaint, the police will invite the accused to lodge a complaint and start bargaining which one, whether do you want the both to be registered in FIRs. And there will be a long delay of filing an FIR, registration of FIR, and the accused will take an advantage of defective FIR, delay in FIR, reasons are not mentioned. And then you see the class bias in the same fashion, you know, very effective FIRs. The state, in 90% of the cases, like in UAPA, the states are the complainants. Sumoto complaints are registered. An effective investigation. You see, for example, in the same case, Rohith Vemula, in this crime, Prashant, in all these cases, apprehended, arrests were taken place, sent to the judicial remands. In spite of statutory provisions are there. That is the reason in the higher judiciary particularly, when the matters come up like atrocity cases, there is no fair trial at all because they are not aware of it. There is no such a sensitization among the judges to deal with the cases of atrocities. They are set free immediately on the bails. Therefore, what I appeal to all, to you, that to achieve these SC/ST prevention of atrocities, it took more than 4 to 5 decades. Now this is almost 10 years we have crossed from the day we have been demanding for a Rohith Vemula Act. Even till today there is it has not moved any step further. Therefore, we all have to come together and consistently we have to plan a program on which we have to build up a pressure, because we see in the history that neither the judiciary nor the state, unless there is a movement, social movement outside, the favorable judgments would not expected from the judiciary or from the state. With this, let us all fight together collectively until we realize the justice in Rohith Vemula's struggle. Thanking you for that.